So Lordship, thank you for the insightful comments. My name is Shahab, I'm a PhD student at King's. So, looking at what we discussed and how things are working in India, it appears that almost all the groups are protected except Muslims. And the role of courts in a democracy, so there is a judgment, actually there are some judgments in which the Supreme Court judge, Justice Gogoi, called categorically Muslims as vultures, Muslim immigrants as vultures and army of ants. So these are the words of the judgment. And then there are judgments of Karnataka High Court in which Muslim hijab ban is placed on Muslim women. So how do you view the role of courts in regard to the group of Muslim minorities in India? Or what's the future of that?
Thank you.
Well, can I answer that, or do we take another?
Just two more.
Sure.
Yeah. Sorry, go ahead. Introduce yourself.
So this is related to the first question that was asked. I think you. Thanks for the wonderful talk. I think you touched upon caste, women rights, gender rights in general, disability, convicts. I think what in recent times, which I think you did not touch upon, was what someone asked earlier, was Muslims or religion in general. And in that context, I had two recent instances where habeas corpus petitions were lying in the Supreme Court for months and even years in the context of removal of Article 370 in Jammu and Kashmir. And more recently, bulldozers have been used on Muslim homes without any judicial intervention. So it would be great if you could comment on that from what the court feels about it. Thank you.
Wonderful. Thank you. Over to you.
All right. Let me deal with some of the common elements in all the three questions. Being a judge imposes some restraints on me in the sense that where there's an issue which is live and which is pending either before my court individually or before another bench of my court, by virtue of the restraints of my office, I can't discuss that case. It would be improper for me to do so. But let me begin by telling you this. Let me look at the broader issue which you first framed, which I'd like to address, which is that this perception that the jurisprudence of the court does not deal with a particular religion, in this case the Muslims. I think this is not a very fair, it's not a fair assessment of the work of the Supreme Court. What happens is that very often the media or social media does not highlight necessarily individual cases which come up before us almost with routine regularity, but which do not provide any fodder to the media, because these are cases where courts deal with cases involving communities, groups of citizens, whether they belong to the marginalized communities or on the political fringe or away from the mainstream. Courts do render justice in those individual cases. Unfortunately, they are never reported in the media. And that I can tell you from my own personal experience, whether it be in the context of the freedom of religion. For instance, you have, apart from Article 25, Article 26, 25 guarantees the individual right to the freedom of religion. 26 speaks about the rights of religious denominations. Then you have Article 29, and Article 30, the right to set up educational institutions of your choice. If you look at the jurisprudence of the Supreme Court, for instance, dealing with linguistic or religious minorities and their right to set up, to establish and administer educational institutions of their choice, there is vibrant jurisprudence which is continuing jurisprudence by the Supreme Court, where rights specifically, not only of linguistic minorities, but rights of religious minorities, including and not confined only to the Muslims, has been consistently upheld by our Supreme Court. Therefore, when you look at the overall perception that you have spoken of the Supreme Court's engagement, I must tell you that what you necessarily read on the media or the social media is not, I believe, a correct statement of what happens in the day-to-day life of every judicial institution in the country. You will have small cases In fact, one of the criticisms of the Supreme Court is, why do you deal with so many small cases? You should, like the American Supreme Court or maybe many of the other Supreme Courts across the world, be dealing with only the issues of constitutional philosophy or constitutional policy. That's not the way our Constitution has framed our role. And to be very honest, I mean, writing a judgment in a very important constitutional issue gives undiluted pleasure to a judge, because that's where your intellectual capacities are stretched to their limit. But the real cases which give you the greatest amount of satisfaction of the judge is when you deal with individual problems. Somebody who has been dishoused, somebody whose pension has not been paid, somebody who has not been allowed to avail of some basic civic amenity. And these are the small cases which come to us involving a cross-section of communities, including, of course, the Muslims. And if you look at the broader context of the work which the High Courts and the Supreme Court do, which unfortunately does not find notice in the media, and I don't blame the media for it, because it's not newsworthy. It's simply not newsworthy because the court has done justice. And because you've done justice and you've brought some sort of solace to a common citizen, never makes its way into the pages. You've spoken of, sir, about the hijab issue. I wouldn't like to answer that because that's specifically pending before the Supreme Court. I only know, of course, as a judge of the court, that it was mentioned for listing and is likely to be taken up by the Supreme Court, as the learned Chief Justice said. So you mentioned about the demolition of some homes in, you referred to the case involving the demolition at Prayagraj. It would not be correct to say that the Supreme Court has not taken up the issue. Again, my knowledge is from reading the newspapers just before I left for London. The vacation bench of the Supreme Court took up the matter on priority when it was mentioned before the Supreme Court for early listing. They have issued notice, which is the first step that the court has to follow, which is you issue notice to the other side, and then once the government in this case or the local authority in this case receives summons from the court, they respond, file an affidavit, and the court deals with the matter. So these are both matters which are live and pending before the Supreme Court. In fact, the position is not that the Supreme Court has not taken up the matter, but that the Supreme Court has taken up the matter even during the vacation. On the issue of the petition involving Article 370,
The habeas corpus.
Yes, I'll deal with the habeas corpus in a moment. The Article 370, that is a matter which has been referred to a Constitution bench. That is before the Constitution bench. Let me just tell you only one thing. I don't want to specifically deal with the merits of that case, because obviously it is pending before a bench of the Supreme Court, which would be hearing the constitutional challenge. But the Supreme Court has 34 judges. We have over 35,000 cases which we deal with every year. On every Monday and Friday, every judge of the Supreme Court is reading between 60 to 65 or maybe 70. There have been times when I've read 120 on a Monday. This is the kind of workload which a Supreme Court judge does. You read about 65 to 70 cases on a Monday, and you read 65 to 70 cases for a Friday, which means for a Monday you are putting in about 12 hours of work on a Sunday. For the Friday, you begin reading on Tuesday. On Tuesdays, Wednesdays, and Thursdays, each of us in the court is dealing with at least between 20 and 40 cases, where you reserve judgments, go home and start dictating a judgment for next day. Together with this, you are reading also for Friday. The workload on judges of the Supreme Court is enormous. Now, it's an important policy issue. Should the court really be dealing with this vast majority of cases? And I can share with you, and I'm sure that I would not really be sharing something which we as judges do not share between each other, which is this really, are we by this huge backlog of cases, this huge inflow of cases which comes to us, are we in that sense not able to deal with some of the more important policy or constitutional issues which come before the court? Now, the vision which the Constitution gave us Article 136 of the Constitution. Now, Article 136 of the Constitution allows us to deal with any case which involves a substantial question of law of general public importance. Very few Supreme Courts across the world have this kind of a provision in the Constitution, as a result of which we are not just a constitutional court, we are also a court of appeal. So on an average, on a Monday, I'll have 10 bail applications. Now, for all the habeas corpus petitions, I'll go to the habeas corpus issue right at the end. These cases never see the light of the day in the media because these are routine cases which the court is handling. They may be routine for the media, but they are of seminal importance for the person to whom bail has not been granted, either by the district court or by the high court. And we look at that jurisdiction extremely carefully. For instance, I'll tell you, there are courts in India, the Allahabad High Court, for instance, is hearing criminal appeals of 1990. Now, there are convicts who have undergone, say, 15 years of actual custody, of actual imprisonment, and whose appeals have not been heard. We have applications for bail of those convicts which come to the Supreme Court, and we have been insisting that if the High Court cannot hear their appeals on an expedited basis simply because of a dearth of infrastructure, it's not that the judges are not there to hear those appeals. There's a dearth of infrastructure. The Allahabad High Court has a sanctioned strength of 160 judges, but you can't obviously have 160 judges in place. Where do you get those judges from? So when you look at these issues pertaining to India, it's, I think, important for us to understand that part of the issue, which case ought to be heard, is again a matter for the Chief Justice of the Supreme Court to decide, and that allocation is made according to roster to judges. But we must understand the context in which our judges decide cases and the burden on the contemporary judge. I don't think our judges had this sort of a burden in 1950 or 1960 or even for that matter in 2000, and it's not getting easier for us, it's getting only more difficult. What's the solution for this? Do we then say that, well, cut out at certain level small cases involving important issues for individual citizens? Or do you continue with this wide sweeping jurisdiction? For instance, some of the cases that I spoke of, if we didn't deal with those cases, we wouldn't be laying down law for the country. Insofar as the habeas corpus petitions are concerned, I must also share with you that again, cases which never see the light of the day are actual habeas corpus cases which we decide. It's not that judges are not deciding habeas corpus cases. Critical habeas corpus cases involving detention of citizens, not just for an apprehended violation of economic laws, but on other grounds as well. They come up before the court. They are dealt with by judges, analyzed by judges. Well, one of the common law traditions which we follow is that we have to hear parties. We don't decide cases merely by reading the briefs and going home. We have an oral tradition. There again, is there a scope for reform? Cut down oral arguments so that you have a little more time for yourself to deal with a larger number of cases. Possible changes for reform, which I think would go a long way in assuaging this concern that the court has to ultimately find time in its docket and calendar to deal with cases. But I'm sorry, I was not being able to deal with specific instances on hijab or Article 370, because that's pending before the court and not be proper for me to deal with it.